Alex here with part 9 of the My Docket series on Corazon Real Estate. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. Going into this particular video, we have the reply to the landlord's opposition to my motion to have him hire an attorney. I can't quite remember my mindset at the time. I figured it was a pretty basic, simple issue. I figured I made my point clear, but I probably did also understand that he was frustrated and angry that the case was in district court and not in justice court, where he was probably used to playing around. He was probably used to tenants fighting him whenever they did, which was probably very rare in small claims court, where he didn't have to worry about things like punitive damages. And I think that that's something that kept his business model safe. Because I really do stand by what I said in part 1, which is if they get 100, if they are able to screw 100 tenants out of something and only one or two of them sues and they only have to pay the compensatory damages, it makes no sense for them to change what they're doing because they get to keep the profit for the other 98, 99 tenants who didn't sue. So punitive damages really is the only thing there that is in place to get them to stop doing something that they shouldn't be doing. And that's I have a very strong belief that it's our state's failure to impose punitive damages against landlords. That is what keeps landlords from doing the things that they're doing in our state. It's built into the business model. I very strongly believe that if you follow the money, you'll find out why certain things are happening the way they are. And it doesn't make any sense to me if a judge gets mad at a landlord and orders him to pay a tenant back, that the landlord's going to stop doing what they're doing when the other 98, 99 tenants aren't suing them in court. It's going to actually cost the landlord more money to do the right thing than it is for them to keep doing the wrong thing. So absent an award of punitive damages, there is no disincentive in place to get them to stop. So I understand that the landlord wants this case in small claims, which is what he's comfortable with and what he's used to tenants doing. But at the same time, ultimately, what needs to happen is that the landlord needs to stop doing what he's doing. In fact, at the very end of the series, I'm going to go through the reviews that are on Yelp and Google, and you'll see that the things that I'm accusing the landlord of doing are apparently still occurring because, and we're just going to scroll through those reviews so you can see the complaints that all these other people have, which is just proof that what I said, in part 1 is it's probably true that a failure of the court to intervene and impose some kind of punitive corrective measure is the reason why these things continue to occur on a mass scale. Anyway, I think for now we can go ahead and take a look at what I have filed. Here we have my reply to opposition to motion to require Corazon Real Estate to obtain counsel. Standard introductory paragraph indicating that I am appearing a proper person, which means I don't have an attorney, and that I am filing a reply to the landlord's opposition to motion filed October 17th, 2012. Okay, I see what I'm doing. I'm citing DCR 13.3 and arguing that he failed to cite points and authorities that specifically oppose my motion. First of all, I don't think it's 13 sub 3. I think it's 13 sub 2 off the top of my head. So I think I cited the wrong subsection. But if I did, I was only off by 1, maybe 2 at most. And I'm reiterating that point here on the next page, is that the landlord's opposition is utterly devoid of points and authorities and should be treated as non-responsive. There are multiple cases from the Supreme Court that indicate as such that you have to cite points and authorities, and that if you do not do so, that you're basically not even responding. I understand from the landlord's perspective, he thinks that he can just use general overarching principles of fairness, logic, and equality, but I'll explain why that doesn't work in the video, Fairness versus the Law. 3 different cases that I'm citing, by the way, those aren't cited correctly. If you want to look at the correct citations, definitely take a look at the later videos in the My Docket series for high conflict child custody, the stuff towards the 5-6 year mark. It looks like these, I didn't understand that I'm supposed to include the Nevada reporter citation, and I also didn't know how to cite to specific pages. But I mean, if this is a big issue, if people are really curious, I might dedicate a video to the topic of how to cite case law, because I'm definitely citing these incorrectly. Doesn't matter. I still end up winning on appeal, but just a thing to point out. And then the last thing I'm mentioning at the final paragraph is that it's imperative that the landlord, if they are permitted to proceed in proper person, that they have to comply with the rules of civil procedure, the district court rules, the Nevada arbitration rules, the Supreme Court rules, etc., etc. We got Rule 5 Certificate of Service indicating this document was mailed to the landlord. Next, we have the request for submission. As with my previous videos in the My Docket series, you can always learn more about how this works in the video titled Request for Submission. Going into the aftermath, I filed 2 different documents. Those were both free filings, so I incurred $0 in costs. And the landlord didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The landlord would eventually be forced to get an attorney. They would probably review these documents. I imagine they would put 15 minutes into them max. So a total of $62.50 in attorney fees for the landlord at the rate of $250 an hour. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.